So tonight, we are happy to be joined by Steven Schwinn, professor of law at the University of Illinois, Chicago, where he teaches constitutional law, civil rights, human rights, and comparative constitutional law. He's a nationally recognized voice on constitutional issues. He is the founding editor-in-chief of the American Constitution Society Supreme Court Review and co-editor of the Constitutional Law Prof blog. Mr. Schwinn is a frequent speaker and commentator on constitutional law and public policy, with work appearing in law reviews, the popular press, and publications from the American Bar Association. He is also deeply committed to civic education, regularly working with high school students and teachers to help promote constitutional literacy. We're very fortunate to have him here tonight, so please welcome Steven Schwinn.
Thank you, everybody. What a thrill to be here with you tonight. Thank you, Ryan. Thank you, Sue. Thank you, Carol, for organizing this. Really appreciate the opportunity to spend a little bit of time with you. I just want to do a quick sound check first off. Can everybody hear me okay? Yes. And then a time check. I think we go until 7:30. Is that right? 8:30. 8:30. I keep thinking we're at 6 o'clock. I'm still on daylight savings time or something. We go until 8:30. Okay, great. And then final thing, I know you have cards that you can write questions on. If it's okay with everybody, can we just keep this as conversational as you want? If you have a question, please just pipe in. I'm more than happy to talk about anything you want to talk about. This is your time, not mine. And I want to give you the information that you're looking for, not that I want to deliver. So please just let me know what you want to talk about. If you have any questions, if you have any comments. As I tell my students, you can please keep your complaints to yourself, but questions and comments are more than welcome. This is a real pleasure and honor to be with you tonight. I've already had some small world 6 degrees of separation moments with a couple of you. Really appreciate that. And appreciate the opportunity to engage with you around these really important topics. So we are, I think maybe all too obviously, at a time of significant constitutional change in our system, a seismic change in the separation of powers. We're seeing a consolidation of power in the office of the presidency like we have never seen in our country's history. And I just want to pause there for a moment. This can get awfully political very quickly, right? I want to try to keep it apolitical, and this is the way I want to do it. This is what I do with my students, with high school students, and anybody that I talk to. Maybe you like what's going on in our politics and our constitutional system right now. That's great. Maybe you don't, and that's okay too. I happen not to very much. What I want you to think about is what we're going to go through here in a few moments. I want you to think about this in terms of whether these powers that are consolidating within the office of the president, if you like them, would you similarly like them if a president that you didn't favor were in office, right? And if you don't like them, would you not like them if a president that you favored were in office? In other words, make sure that your constitutional commitments work both ways. And if they don't, maybe we need to check our constitutional commitments. And I'll be quite upfront about mine. I think we're dealing with a period right now with outsized presidential power like nothing that we've seen in our country's history. And I think it's downright dangerous. We can talk a little bit more about why I see it that way. Many of you may share that view. Some of you may disagree, and that's okay. But kind of understanding and unpacking what's going on in our separation of power system, I think is just so important at this moment in time. And that's why I'm so grateful for the opportunity to spend the next hour and so with you. What I'd like to do is kind of take a step back and look at 30,000 feet, what I think is going on here, and then take a couple of examples that sort of illustrate a long-term trend that I'm seeing as a constitutional scholar, share those ideas with you, get your reactions, and of course, get any questions or comments along the way. Happy to hear about it. Does that sound fair? Okay, so I gotta confess, it's always tough to know where to start. It's like every time I open the New York Times, there's something else to talk about that night, right? It's like a fire hose of material coming at us around the separation of powers. different things coming out of Washington, politics, constitutional law, all this stuff is just kind of going bananas these days. I call it the Trump administration is the Full Employment Act for constitutional law professors like me. It keeps us doing our job. And so I'm deeply appreciative of the administration, if for nothing else, to keep me in my job. What's going on, I think, is easy to attribute to President Trump. And we often do that. And that's kind of the standard line in the media. If you watch MSNBC or even Fox, right? A lot of people say what's going on right now has to do with Trump and MAGA as a movement, and this particular president aggrandizing the office of the presidency and consolidating power within the White House in ways, again, that we've never seen before. And I think that's partially right, but I want to put a little wrinkle into the story. I think actually what's going on is that we're seeing a 30, 40, 50-year trend in our jurisprudence through the Supreme Court, our constitutional practices between Congress and the presidency that have met this moment of the MAGA movement and President Trump. In other words, we've seen a long-term trend moving toward an aggrandizement and consolidation of power in the office of the presidency at the Supreme Court, at Congress, and at the White House. This is a long-term trend. And it met a president who was willing to grab that trend, ride that wave, use this as a springboard to consolidate their own power, maybe for their own reasons, maybe for public policy reasons. We may agree or disagree about why this is going on. But I think what's happening is that, yeah, President Trump is responsible for some of this power consolidation in the White House, for sure. But he's not acting alone. He's doing it with the full complicity of the Supreme Court and Congress over a 40-year time horizon that I'll walk you through in a moment that makes everybody in Washington these days complicit in what's going on. Now, again, maybe you like this and that's great. And if it does, the story I'm about to tell you is a happy tale. Maybe you dislike it, in which case the story I'm about to tell you, I think, is a cautionary tale, but also a hopeful one. And here's kind of the punchline that I'll tell you right now and remind you at the end. If you don't like what's going on, it's not, this didn't happen by magic. It happened over a 40, 50-year time horizon, a very carefully orchestrated political campaign in the courts, in Congress, and in the White House by people that are smart and dedicated and talk about this stuff and are engaged with it to make the kinds of changes that we're seeing today in 2026. What I tell my students and what I'll tell you is, if they can do it, we can too. If they can do it, we can too. And so if you don't like what's going on, they've given you a roadmap for change because they got us here, they can get us out of it. Let me talk about 3 different areas where I'm seeing these trends kind of move and transpire. And you may have other areas that you want to talk about too, and I'd be grateful for the opportunity to talk about them. So one area is around direct consolidation of power within the office of the presidency under something that we call the unitary executive theory. Does that resonate with anybody? Unitary executive theory, have you heard that? Okay, so we'll talk a little bit about that. I think that's really the most powerful story that I can tell you. Second, I want to talk about equal protection and non-discrimination and DEI. Have you heard that phrase DEI, diversity, equity, and inclusion? And what's going on in the administration with regard to DEI and how the Supreme Court set the stage for what we're seeing today in 2026. And then finally, I thought we might, if it's okay with you, thought we might talk a little bit about war powers. What do you think? Maybe relevant? I don't know. So if we have time and energy, we can talk about war powers going back to 1972 in reaction to the Nixon administration, the War Powers Resolution that was passed over the veto of President Nixon and now is designed to operate as a check on the presidency, but actually doesn't really operate as a check on the presidency with regard to their war powers. And so what I want to do is just take a look at those 3 trends over the last 30, 40, 50 years and see kind of how the courts, Congress, and the presidency have led to this moment in 2026. In some ways, not a surprising moment at all when you have a character like President Trump, who again is willing to ride this wave and take it to the extreme. Are we ready to go? All right, let's start with the unitary executive theory. Somebody who's heard about the unitary executive theory, just to kind of make this a little more interactive, can you share with us what you know about it? Go ahead.
Most recently, I noticed it having been promoted by then Vice President Cheney and popularized in a movie about his life, a biography. And I really hadn't been aware of it prior to that aspect in the early 2000s.
Good. And Dick Cheney is a key character in the evolution of the unitary executive theory and where we are today in 2026, going all the way back to the Iran-Contra scandal in the Reagan administration. Do you remember that? Yeah. So he had an early start in this, carried it through the second Bush administration, and then provided a platform for Project 2025 and the Trump administration today in 2026. Good. Other people who've heard about it. Yeah.
My understanding, part of it is that the president has complete control of the executive branch, and that attempts by Congress to limit his authority, for example, to fire or remove heads of branches of the executive are unconstitutional.
Excellent. Good. That's a very nice legal summary of what the unitary executive theory is. And what I like about the way you've described it is you've described it at different levels of generality, right? At one level of generality, it's about the president's power to fire people within the executive branch. But at another level of generality, it's broader. It's the president's power to direct anything in the executive branch, which is pretty broad, right? Let's start this story back in, where to start it? Well, I'm going to start it in 1988 with a case involving the old independent counsel. This is not the Jack Smith independent counsel. This is the independent counsel that was designed under the Ethics in Government Act, again, as a reaction to some of the overreaches in the Nixon administration. The way this office was designed is that there's an attorney who sits within the Justice Department and answers up the chain within the Justice Department, okay, ultimately to the president. But the way the office is designed, the president can't remove this attorney except for good cause, right? Now, that for good cause protection provides an extra layer of protection so that the president can't remove this person for mere political reasons, for example. There has to be good cause to remove them. They're showing up to work late, or they're drinking on the job, or they're just not doing a very good job prosecuting, something on the merits, not because they don't like the politics. That's often how Congress designs offices within the executive branch to be politically independent from the day-to-day politics in the White House, right? If Congress thinks we want a particular office in the executive branch to not answer directly to the president's political whims, but rather to do a good job regulating the economy, prosecuting wrongdoing within the executive branch, regulating the securities and exchange markets, regulating federal elections, right? There are a whole alphabet soup of these agencies where Congress has designed them to be politically independent from the president so that they can do good governance work. That's the whole point. Now, I want to say Congress has the authority to do this under Article 1 of the Constitution. That's what Congress does. It writes laws and creates these agencies to enforce them. Not only that, Congress creates the agencies, but then it vests them with authority. It tells them what they can do and what they can't do. And then finally, Congress gives them money to do it. Remember, Congress has the power of the purse. So Congress funds these agencies. That's a ton of power that Congress has over these agencies that are located in the Article 2 branch and answer ultimately to the presidency. So this isn't your standard corporate model, right? It's not a CEO model of the presidency. This is where Congress has a tremendous amount of control in creating agencies, vesting them with authority, and funding them, irrespective of what the president says about their day-to-day operations. Now, of course, the president has some say in how they operate. Of course they do, right? After all, the president is their ultimate boss. But it's important for us to remember when we're talking about the unitary executive theory that under the plain terms of the Constitution, we can all read Article 1. It says right there, Congress can create these agencies, vest them with authority, and fund them, and destroy them if it wants to. And only Congress can do that. So anyway, back to 1988 and the independent counsel. In 1988, a target of an independent counsel investigation didn't like the way the independent counsel office was designed. In particular, they didn't like that the president couldn't remove the independent counsel for any reason at all. The argument went something like this. The president is charged under Article 2 of the Constitution to execute the law. And in that sense, they're the chief law enforcement officer in the United States, right? And anybody who's charged with executing the law within the executive branch, especially a prosecutor, which is a core executive function, must answer directly to the president and be removable at will by the president. And if they're not, the president doesn't have enough say-so in executing the law. In other words, what they're saying is that by designing the office in this independent way, what Congress has done is impermissibly encroached on the executive authority of the president themselves. Do you see that? Congress has the authority to design the office, sure, but if they design it in a way that encroaches on the president's power to execute the law, then they've impermissibly encroached in violation of the separation of powers. That was the core argument. It went all the way up to the Supreme Court, and the Supreme Court rejected the argument, overwhelmingly rejected the argument by a 7-1 vote. 7-1 doesn't add up to 9. Justice Kennedy recused himself. The one dissenting vote was Justice Scalia, who some of you may know. Justice Scalia dissented, and in a lengthy and vehement dissent set out what we today understand as the unitary executive theory. What Justice Scalia said was that the president must have authority over prosecutors in the executive branch. If the president doesn't, then Congress has impermissibly encroached on the executive power of the president in violation of the separation of powers, and this office is invalid. A single vote on the Supreme Court. Now, since 1988, there's been a group, and here I don't want to point too many fingers, but I'm going to point some fingers. There's been a group called the Federalist Society. Anybody know the Federalist Society? Yeah, okay. Group of politically conservative legal scholars and lawyers, judges, and they set out in the 1980s, actually started right here in Chicago, set out in the 1980s to educate law students who then would become lawyers and judges, right, in their way of thinking about the separation of powers. And that included this idea of unitary executive and promoting Justice Scalia's view of the unitary executive. They were so successful that they now have probably 6 justices on the Supreme Court who would sign on to Justice Scalia's dissent in Morrison, going from a single justice view in 1988 to probably 6 justices today in 2026. It's just jaw-dropping how successful this, again, a political movement was, right? And so these things don't fall out of the sky. These are things that you and I can do if we have the time and the resources and the energy to do it. This is how constitutional change is made in our system. And you can see how rapidly it was changed. After 1988, in the early 2000s, we saw a couple of cases come down from the Supreme Court that moved incrementally in the direction of the unitary executive theory. But these were all cases involving the president's authority to remove officers within the executive branch. And so again, it was limited so far to that core of the president's power to remove officers in the executive branch. We had a good number of justices, a majority on the Supreme Court, who were ruling in favor of Justice Scalia's unitary executive theory, but they were doing it in a circumscribed way. They were doing it only with regard to the president's power to remove federal officers, right? Now, that's not nothing, but it is what it is. Then comes President Trump. President Trump and Project 2025 and the MAGA movement and some of the attorneys behind the MAGA movement said, you know what, this unitary executive theory, it actually means much more than just the president's power to remove federal officers. Sure, that's the core of it. But if we move outside of that core, it must also mean, just by extension of reasoning, it must also mean that the president has plenary authority, unilateral authority, to remove any employee in the executive branch, any employee, notwithstanding merit systems protections, notwithstanding civil service protections, notwithstanding union contracts. None of that matters to unitary executive theory. The president has authority to fire any employee in the executive branch. Now remember, Congress designed all this, right? Congress wrote into law civil service protections, merit systems protections for these individuals, and the power for them to engage in collective bargaining. So when the president comes in and says, I have plenary authority to remove them from office, he's steamrolling all this federal law that's protecting these employees, right? And by the way, then he removes the officers on the Merit Systems Protection Board and the inspectors general and other watchdogs in the executive agency under a unitary executive theory so that the removed employees don't have anybody to complain to, right? They can't bring their case to the Merit Systems Protection Board anymore because it's not there, because Trump removed them under a unitary executive theory. Okay, so now we've moved out a circle, right? We're not only talking about officers, but now all employees, but there's more. Not only Project 2025 says, and the Trump team says, not only can the president under the unitary executive theory remove all employees in the executive branch at will, not only that, the president can destroy entire agencies, can just dismantle them or reconfigure them in any way that the president sees fit. That's part of the unitary executive theory. It's just an extension of the reasoning of Justice Scalia in that Morrison case going all the way back to 1988, right? Just an extension of the reasoning. And so we see USAID dismantled. We see the Department of Education almost fully dismantled. The Consumer Financial Protection Bureau, almost fully dismantled. A number of other agencies reconfigured and dismantled in ways, again, that cut directly against the federal law passed by Congress that created these agencies, vested them with authority, and funded them. The president says, I can steamroll all that, it doesn't matter, because I have this unitary executive power, or as President Trump says, I have an Article 2. But not only that, the president's team in Project 2025 says, not only can we remove officers, can we remove employees, can we dismantle agencies, we can also shut down funding. If we don't want to fund projects for USAID, or we don't want to fund Harvard's research, or we don't want to fund the CDC anymore, we can just shut down the funding, right? That's called impoundment. And Congress, again, in reaction to the Nixon administration, passed a federal law. It's called the Anti-Impoundment Act. The president can't impound money. The president doesn't have the authority to do that. If Congress allocates a sum of money for a particular function in the executive branch, the president is obligated to spend that money for the function that Congress designated. Again, Congress has the power of the purse, not the president. But to the unitary executive, that doesn't matter because the president has unitary power over everything in the executive branch, including the power to impound federal funds. And this, I'm not making this up. This is all right there in Project 2025, which, by the way, was available before the 2024 election. So we kind of went into this with eyes open, right? Okay, not only that, now we're moving out again. Not only can the president shut down funding, but by extension of the reasoning, the president can ignore federal law. The president can ignore federal law. The president isn't bound by federal law. And here, not only is the president drawing on the logical extension, or at least what Project 2025 says is the logical extension of Justice Scalia's dissent in the Morrison case, but also drawing on a 2024 case that maybe you've heard of, Trump versus United States, the immunity ruling, right? Where the Supreme Court said that the president enjoys absolute immunity for any action taken within the president's conclusive and preclusive Article 2 power and then proceeded to set out a roadmap for the president to take effectively any action the president wanted to, and figure out how to put it within that conclusive and preclusive power to immunize themselves from criminal responsibility and immunize them from any federal law. What the Supreme Court said in that case is not only is President Trump immune from criminal liability for acts within the conclusive and preclusive space, things like accepting a bribe for a pardon, the president can't be prosecuted for, right? Not only that, Congress can't regulate it at all. Congress has no regulatory authority over the president's action in that conclusive and preclusive space. And moreover, the president's enforcement power very well might fall within that conclusive and preclusive space. And if so, Congress can't tell the president what to do. The president is above the law. Isn't that something? And again, this is all in Project 2025. Yeah.
So Congress has the right to impeach the president.
Yeah. Sure. And that's the stock response. So the question was, well, Congress can impeach the president. And so isn't that something? And the answer is, yeah, it is. Congress can impeach the president. There are 25th Amendment remedies against a president. And so if Congress had the will to actually impeach and then convict and remove a president, they could do that. Yeah. But here's where Congress seems to be falling down. And again, I don't want to be political about this, but the truth is that the framers designed our system so that when one branch pushes too hard, the other branches will push back, right? They designed our system specifically with the knowledge that it's human nature to reach for more power, right? And so they expected all three branches to do that. But what they expected is that when one branch did it, the other two would push back and keep the system in check. If the courts aren't doing it and Congress isn't doing it, we're losing our checks and balances. Isn't that something? And so now we've seen the Supreme Court ratify or effectively ratify this really robust unitary executive theory, not even on its regular docket, but on its shadow docket, right? You all have heard about the shadow docket. So the shadow docket is an emergency docket of the Supreme Court. And I'm going to describe a pattern that we've seen in litigation time and time again. I think by last count, there were maybe 600 cases against the Trump administration. And the typical pattern in these cases is Trump administration acts, federal district court issues an injunction and halts the act. The Trump administration files an emergency appeal to the Supreme Court, and the Supreme Court halts the injunction, thus letting the administration's act go forward. Now, the Supreme Court on the shadow docket doesn't explain its rulings, and so we don't really know what it's thinking. But the trajectory of these decisions suggests, and the lineup on the Supreme Court suggests, that it's going full-blown unitary executive on us, and that it's adopting this Project 2025 vision of the unitary executive theory, this hyper-robust vision of the unitary executive theory. Yeah.
Isn't there a big difference, though, between saying the president has control over the personnel of the executive branch, and saying the president doesn't have the responsibility to execute the laws that is written by Congress, and then takes the oath, I will faithfully execute the laws of the United States, and Congress makes the law. So the effective dismantling of an entire agency created by Congress seems to be not faithfully executing the law.
Well said. Yes, that would get an A+ in my class. So the comment is, this isn't faithfully executing the law. The law is what the law is, and if the president isn't executing it, they're not doing their job. Yes. So here's where the unitary executive theory, I think it's textually, it goes to the vesting clause in Article 2 that says the president has the power to execute the law. The president has the executive power. And what Justice Scalia and unitary executives would say is that means all of the executive power. And part of the executive power is a discretionary authority not to enforce the law in this or that case, right? Think about your local prosecutor. Local prosecutor makes a lot of tough executive decisions every single day. Some of the decisions that they make include decisions not to prosecute for a variety of complicated reasons. Maybe they don't want to spend resources on the prosecution. Maybe they don't think that this particular defendant is especially guilty. Maybe, who knows why, right? But we build that into our executive function system, this idea of prosecutorial discretion. Well, if you take the idea of prosecutorial discretion and kind of explode it across the Article 2 branch, that's where you get this hyper robust executive power not to enforce the law if they don't want to. And so, okay, well, maybe that works in this or that case, but what about every case? That's just the logical extension according to Project 2025. And I'm not defending it, I want to be clear, but just setting out the reasoning. Yeah.
After North Dakota said they couldn't fire Jerome Powell, but they could fire anyone else.
Oh my goodness. Okay, so this is what we're dealing with today. Yeah, is this why the Supreme Court said that President Trump could remove an officer of the Federal Trade Commission and other officers in the executive branch, but not Jerome Powell from the Federal Reserve? So this all happened on the shadow docket, and these cases are now before the Supreme Court, and the court has briefed them and heard oral arguments on them. We'll probably get decisions in late June or early July. The case where President Trump removed a commissioner from the Federal Trade Commission who enjoyed for-cause removal protection, just like the independent counsel in the Morrison case that I described, sued and said, you can't remove me. There's no cause. You can't remove me. And the Trump administration is arguing basically a unitary executive theory. Oh, yes, we can remove you because any removal protection that Congress provided is invalid. It impermissibly encroaches on the president's executive authority for the reasons that we've discussed, and therefore is invalid, and the president can remove this person at will. I think the Supreme Court's going to rule that way, one way or another. The only question is how broad or narrow the court's ruling is going to be. That doesn't answer the question, why did the Supreme Court halt the Trump administration's firing of Jerome Powell, a governor on the Board of Governors of the Federal Reserve? Well, a cynic might say that the Supreme Court justices are just as concerned about their 401k plans as you and I are, right? A cynic might say that. Now, I'm not saying it, but a cynic might say that. What the court would say is that there are meaningful differences between the Federal Reserve and other federal agencies, that we have a precedent, a long-running precedent in the United States of an independent federal bank going all the way back to the early 19th century that sets a kind of practice as precedent, a kind of historical precedent for the independence of the Federal Reserve. Now, many of us who study this stuff think that's crazy, right? This is nothing like the bank in 1830. But what I say doesn't really much matter to what the court's going to rule. And so we're likely to see the court preserve the independence of the Federal Reserve, but take away the dependence of every other federal agency. Yeah, isn't that something? Yeah.
So let's say in the future, the party of the president changes. What does that then look like if the other party decides to take advantage of all this authority that they have, and then it changes again in another 4 years? I mean, what does that look like?
We're in uncharted territory, so I really don't know. And indeed, if we look at trends in other countries around the world where similar things have happened, we haven't had a kind of party change that would allow us to test that question. We have a maybe test case in President Biden's election in 2020. And what we saw is the administration walk back some of the overreach of the Trump administration, but many would argue used its own overreach. And for example, COVID restrictions, student loan debt relief, right? There were some things that the Biden administration did too that many said were questionable. It's hard to say what it means. I mean, my hope is that we would get a president of either party. I don't care what the party is, but a president who comes into the White House and says, we're done with this unitary executive theory stuff. We're moving beyond it, and we're going to restore some normalcy and balance in our checks and balances. I don't know if that would happen, and I don't know how effectual it would be. Right, and then it's a kind of race to the bottom at that point, right? Yeah, yeah, not a hopeful situation. The other thing that worries me quite a bit is that when you've got a president who's willing to walk back presidential authority, they're often seen as weak and get voted out of office for that reason. Yeah. Oh, yeah, yes, go ahead, please.
What is the objective of these people who are doing these things? They want to destroy the project, destroy. Because it seems to me that, from what I understand, it's so common. One of the lessons I learned for myself is I have no idea what democracy in this country was. No. Every day I find a new surprise that surprised me. How could this be? Anyway, what is the objective of these people? Because that's the big problem, and a lot of people are not only aware or ignorant, supporting. What is the
It's a very thoughtful comment. Thank you. The question is, what's the motivation for this? I'm going to give you three theories that I have, and other people have different ideas. One theory with regard to President Trump himself is that he's in the presidency to line his pockets. And he's been very, very effective at that. A unitary executive theory allows him to do that without judicial check. And if Congress is asleep at the switch, which it has been, he can go full bore and line his bank account. And that may be what's going on with President Trump. What's going on with the broader Project 2025 and Dick Cheney's involvement in this? I think that there's a camp that has a sincere belief that we have a sort of extraordinarily powerful president in our system, and that we for too long have ignored that in our separation of powers way of doing things. And so I think if you administered truth serum to somebody like Dick Cheney or David Addington or Project 2025, what they would say is, look, we truly believe this is what the Constitution says. Okay, I get that. I think the other thing that might be going on, I mentioned the Federalist Society. I think in the 1980s, what a number of people thought was the political advantage for political conservatives was with the presidency, right? In the 1980s, you had Congress after Congress dominated by Democrats. You had Reagan come in with the Reagan wave in the 1980s. And I think what a number of folks thought was, on the conservative side of the aisle, we can get folks elected to the White House, maybe because of the Electoral College, maybe for other reasons. We can't take Congress, and so let's lean into presidential power, right? And so I think those are my kind of working theories, but I'd be curious to hear what other people think on that score. Of course, yeah. Before we do, did you have a question?
So what function does Congress play if we just stop right here and say there's this much executive power? Then what is the point of having Congress? What are they, how do they function?
Exactly. Yeah. And I think it's going to be really interesting if Democrats take the House in the midterm elections and maybe even the Senate. What happens? What's their game plan? What's their strategy? It's not entirely clear to me what it would be. I don't think it's going to, it can't just be obstructionist, right? It's got to be something positive and forward looking, but it's not clear to me how they do that in this political environment.
So do we need amendments to the Constitution that could correct this? Or is that really not?
I think amendments probably are a non-starter, just given how divided we are and how hard it is to get them passed. But I do have some thoughts about what we can do. And I gotta say, I mentioned a couple of you and some of you know that I do a lot of work with League of Women Voters. I adore this organization. And this is the kind of stuff where change happens. And so keep doing what we're doing. And I'll have some other ideas too. But I do want to pivot and talk. Let's maybe take one more question and then we'll go on. Yeah.
A little bit about originalism as an interpretation.
Oh, goodness. Yes. Okay. So let me say, I'm going to use this as a pivot point. I'll talk about originalism in the context of the unitary executive theory, and then we'll move on and talk about DEI, where originalism plays a role as well. So originalism is also an idea that kind of evolved in the 1980s, started in the 1980s, and has evolved into a sort of a variety of different family of theories of constitutional interpretation today. But it's most associated with politically conservative constitutionalism, which aligns with the Federalist Society agenda, loosely aligns with Project 2025, and kind of loosely supports what President Trump is doing with our separation of powers. But more and more, we're seeing progressive pushback on that. And more scholars, independent nonprofits, are doing a lot of good work showing that an originalist understanding of the Constitution is not inevitably politically conservative. In fact, more often, it's politically progressive in today's politics. But in truth, talking about conservative or progressive in 2026 wouldn't make any sense to James Madison or Alexander Hamilton. That's like what we're doing just doesn't make sense to them. And so it doesn't line up very well. But originalism plays a role in the unitary executive theory because a lot of unitary executive theorists point back to a congressional decision in 1789, the decision of 1789, where Congress had to decide whether, when it created certain offices within the executive branch, the Treasury Department, what was then called the War Department, apparently again now is called the War Department, and Foreign Affairs, that when Congress creates the heads of those agencies, the president gets to nominate them, right? And then the Senate confirms them under Article 2. That's the way officers are appointed. The important question for the decision in 1789 was, does that mean if the president wants to remove one of those officers, they have to get Senate consent? And what Congress ultimately decided, Congress was wildly divided on that question, like hugely divided on that question. What it ultimately decided was not to decide. And that was an intentional thing. They just left the question open. Originalists look back to that and say that decision supports the unitary executive theory. What it means is that Congress can play no role in presidential removal of officers, when in truth, what it meant was Congress couldn't figure out what it wanted to do and basically left the question open to future generations. So that's just one example of how originalism kind of distorts the way that we're thinking about things today because it's such a bad fit. And I'm just going to say one more beat on originalism. I'm a lawyer. I love lawyers. They do good work generally, but they're not historians. And for lawyers and judges to be doing history, they just do a lousy job at it. And all we have to do is look at recent Supreme Court rulings to see why that is. So let's talk about DEI, and we'll talk more about originalism in that context. Okay, so what's going on with anti-discrimination and DEI today? This is a really interesting story too. It goes back a little bit further. It goes back to 1954 with Brown versus Board of Education. We all know Brown, right? I want to frame out Brown for you in a particular light though, because it informs how we understand anti-discrimination today and what the Trump administration is trying to do with anti-discrimination and DEI efforts in the federal government, higher education, corporate America, and even in the nonprofit world. So Brown versus Board of Education, of course, overturned Plessy versus Ferguson, right? Plessy versus Ferguson said, remember the rail car case, said that separate rail cars for people of different color did not violate the Equal Protection Clause so long as they were equal. And I'll use air quotes there because equal here has special meaning. Everybody knew the rail cars weren't equal, right? But the fiction was that they were equal. And so that if we sorted out Black people and white people, and pardon me for talking in terms of just Black and white, I obviously recognize diversity, but that was the reality of the time. Sorting out the cars for Black people and white people, as long as they're equal, that satisfies the court's notion of equality. Fast forward to 1954. In litigating Brown versus Board of Education, in order to overturn Plessy versus Ferguson, it was critical that the attorneys were able to find school districts that were segregated by race, but equal. If they were unequal, as so many segregated school districts were, it would be easy to say that segregation was unconstitutional. After all, it led to determinate unequal results, right? But what about if they're equal? That's the hard thing. And so attorneys, and again, these are hardworking, smart attorneys, civil activists, and others who put their heads together over a period of decades to get to the point of Brown versus Board of Education, finally were able to identify school districts that by facial measures were equal, but nevertheless segregated, and therefore take on Plessy versus Ferguson head on. And they did, and they won. What the Supreme Court said in Brown versus Board of Education is that separate is inherently unequal, right? In part because of the unequal results that the attorneys were able to demonstrate in court that Black children were experiencing as compared to their white peers in segregated school districts that were equal. Now, here's the puzzle with Brown. In Brown, you've got equal treatment, right, by stipulation. We'll just say because you have to get over Plessy versus Ferguson. Equal treatment, but a disparate outcome, right? What that suggests is that if the government treats people equally and the outcome is disparate or unequal, that there must be something else going on that produces that inequality. It's not the government treatment itself. It can't be. After all, that's equal, right? If we were an equal society and we split kids into Black schools and white schools, and there were no systemic discrimination, for example, we would expect more or less equal results in the schools. But that's not what they found in Brown versus Board of Education. So by one reading of Brown versus Board of Education, in fact, the predominant reading at the time was a kind of anti-suppression reading of Brown that recognizes that there's something in society that's causing this disparity, that even when government treats people equally, the result is unequal. Do you see that? Now, today we might call that, again, something like systemic oppression, systemic racism. We have a lot of terms for that kind of hardwired inequality in our civil society. But back in 1954, the court didn't have that language. It just said, look, if the government's treating people equally and there's an unequal outcome, there's something going on there. And we're going to call that unconstitutional. That's a violation of equal protection, right? Okay. Anti-oppression, anti-oppression kind of model of equal protection. Through the desegregation decisions in the wake of Brown versus Board of Education, through the 1980s and then the 90s, and then in the early 2000s with more desegregation decisions, the Supreme Court started moving away from this anti-suppression or anti-oppression view of equal protection in Brown versus Board of Education to an anti-classification view of equal protection. What the court started to say was, Brown didn't say that separate but equal leading to unequal results is unconstitutional. What Brown said was simply labeling people Black and white is what is unequal. In other words, it's the disparate treatment itself. It has nothing to do with the outcome. That's the inequality constitutional violation. Do you see that shift? It's a fundamental shift in thinking about Brown from a kind of anti-suppression model of equal protection to anti-classification, where the worry about inequality is not what's the result, but rather does the government label people by race? And if the government labels people by race for any purpose whatsoever, whether that's an evil purpose or a laudable purpose, a bad purpose or a good purpose or a purely equal purpose, whatever purpose, it's the labeling alone that is the constitutional problem. And that shift then in thinking about Brown versus Board of Education led the Chief Justice, the current Chief Justice of the Supreme Court, in a case in the early 2000s involving desegregation of school districts to say this: the way to stop discrimination by race is to stop discriminating by race, which on the face of it seems like a truism, right? But if you filter that through the lens of an anti-suppression model of Brown versus Board of Education, that's nonsense. Do you see what I'm saying? Yeah.
So if you're making decisions, so if you're teaching who's race, then by definition, then you're making decisions based on who's race, and so there seems to be kind of a.
It's the racial labeling, period, that is the problem. And so we think about a more recent case. We think about the affirmative action case, Students for Fair Admissions against Harvard and the University of North Carolina, where the Supreme Court struck down affirmative action in higher education admissions, right? What the court had previously said was, there are reasons that schools can use race as one among many factors, not for a quota, not for points, but one among a diversity of factors. Somebody was really happy about our talk tonight. Did you hear that? The ice cream truck? One of a diversity of factors, right? Race can be one of these factors in higher education admissions, and there are complicated reasons why the court had previously said that schools can do that, right? In Students for Fair Admission, what the court said is no, it's the racial labeling that's the problem. As soon as a school labels a candidate for admission as white or black or Asian or Hispanic, as soon as that happens, that's the constitutional problem. We don't care about the outcome. We don't care what happens in society, this systemic racism, for example, that might lead to a disparity in admissions if we don't consider race. We don't care about that. We care about the racial labeling itself alone. That's where the court was in the early 2000s. That's where it was again in Students for Fair Admission versus Harvard. Fast forward to the Trump administration. Now the administration says any racial labeling is unconstitutional. And my Justice Department, my Civil Rights Division, and the Education Department, everybody else in the federal government who has anything to say about anti-discrimination and equal protection, they're going to go out and prosecute people that label by race for any reason, even if they use labels like DEI. Isn't that something? And so again, what we have is a kind of long-term trend starting soon after 1954, Brown versus Board of Education, and the desegregation decisions that followed that case, tracing through the 1980s, 1990s, early 2000s to the SFFA case, inviting the Trump administration to take this particular view of anti-discrimination and DEI. And the Trump administration was more than willing to do it. In fact, I heard, maybe you heard this too on NPR today, this afternoon, I heard an interview with President Trump's appointee to the EEOC. And she said, I don't know if she knew she was quoting Chief Justice Roberts, but she said, you know, the way to stop discrimination by race is to stop discriminating by race. She said it, and that's exactly what they're enforcing. So what the targets of enforcement these days are practices that discriminate against white men, quite frankly. And she said that during the interview as well. That's the target, irrespective of what the outcome is. And we see that time and time again now in higher education, in the corporate world, and in the nonprofit world, kind of across the board.
So they're saying there's never been gender discrimination?
I'll try to be generous to the court. I think what they're saying is not that there's never been discrimination, but that the discrimination that occurs outside of state sanctioned discrimination is not the court's concern. So if there's hardwired systemic inequalities by sex or by gender or by race or by any other immutable characteristic, if those are hardwired in society, that's not the court's concern. The court's concern is eradicating labels, frankly, because they see that as the way of overcoming sexism or racism in society.
So women should just apply as a male first name?
Well, I don't know, you're gonna run into problems with that too, because they're not so keen on, sex transitioning kinds of things in the Trump administration either. I mean, but even names, I mean, that's kind of the extent of this. And I'll tell you, universities across the country and we at UIC too are dealing with this. What do you do in this environment where we have built an entire system out of commitment to diversity, equity, and inclusion, which just 3 years ago were not problematic and all of a sudden are? What do you do? It's creating a lot of problems. Again, the story, maybe you don't like this, maybe you like it. Think about the way the change was made, right? The change was made over decades of effort by people in civil society, by attorneys litigating cases, by Project 2025, working this idea of anti-labeling into our collective consciousness to such a degree that there are now 6 justices on the Supreme Court that fully sign on to this idea and overturn decades of affirmative action in the form of SFFA or decades of prior desegregation rulings in the parents involved case in the early 2000s. It really is quite stunning to see how this has changed over time. And so again, my message is, maybe you like it, and if so, that's great. Congratulations, your team did a great job. If you don't like it, you got a roadmap, right? And let's roll up our sleeves and get out there and do the same thing because we know how to do it. We know it can be done. It's happened right before our eyes. So let's take the power and do it ourselves.
How do we do that? The court is what the court is, and they are the final arbiter of these interpretations. We could litigate till we're blue in the face, but we're not going to win.
So I think there are a lot of ways to do it. One way to do it is to follow the playbook that the Federalist Society and Project 2025 has followed, and that is to work in the law schools, work in colleges and universities, work even in the high schools. And I don't know if you read this recently, but I'm blanking on Charlie Kirk's organization, the name of it, somebody help me, Turning Point. Turning Point now is looking to establish chapters in high schools, right? Brilliant strategy. We know this works, right? Right here? Yeah, there you go, right? So why aren't we establishing progressive organizations, or let's leave politics out of it, organizations that favor our view of the way things ought to work? Why aren't we doing that in high schools, right? Let's reach to these populations. We have a roadmap for it. We know it works.
We don't seem to have the same collapse and consolidated point of view that the Project 2025 or the Turning Point. We are a bigger organization, a bigger basket, and I think it might be hard to say that what I think is important may not be what other people in this room think are important, but I think we would all put ourselves in the same basket.
Yes, I hear that. I will tell you, and many of you may have had this experience too. Whenever I work with high school classes, and I do a lot, or students on our undergraduate campus, like there's an excitement and a thirst for something to hold on to. And, Turning Point tapped into that. And I think others can tap into it too. Even if they're not quite as focused and organized. as Turning Point is, I get a lot of inspiration from our youth and think that there's a lot of potential and hope there. So that's one way, but there are other ways, right? We know, I think about these as point of access in our democracy. So we know that we can vote, right? We got to vote. Of course, you got to vote. You know, you can get involved in campaigns. So get involved in campaigns. You know, you can contribute financially to campaigns and support candidates in other ways. So let's get out and do that, right? We know that we can contact our elected representatives and instigate for change. And we can do that in collective action. And League of Women Voters does an awesome job of that. So let's get involved in those campaigns. We know that there are other points of access in our democracy that are less well known, but no less effective. And so let me give you one. Federal agencies that we've been talking about when we talk about the unitary executive, they issue rules and regulations, right? They issue rules and regulations to help them enforce federal law. Now, under the Trump administration, many of these rules and regulations are going in a direction that I don't like at all myself, and maybe you don't like either. Here's the thing. Before an agency issues a regulation, they have to go through a notice and comment period under federal law. They have to, before they issue their regulation as a final rule, which means that anybody, including you and me, it doesn't have to be an organization, it doesn't have to be a nonprofit, an individual can write in and comment on regulations. So when, you know, our Attorney General, Pam Bondi, has issued draft regulations that say that state regulators are no longer the front line in regulating Department of Justice attorneys' professional responsibility and ethics, that the Justice Department has to do that as a first cut, right? And if you know what's going on at DOJ, you understand the significance of that. Well, I can write in and I can say, hey, I don't like that one stinking bit, and you can't do that, right? Now, that doesn't mean that it's not going to happen, but by law, they have to take it into consideration. And there are other opportunities to get involved in our democracy in that way. So collective action, individual action, points of access in democracy using our voice and all the things that we know. Another way, and you undoubtedly know this as well as I do, but there's a movement now where people are taking action into their own hands, right? And so, for example, if you don't like ICE enforcement in your neighborhood, do things to support unauthorized non-citizens in your neighborhood. I heard about a group in California, and this is probably happening in other areas of the country too, that have a walking bus for school children to go to school every day. Now that's a hassle, it's a pain in the ass, everybody gets that, but you see the kind of civil action, the civilian action that we can take that we can do. I heard another story about where in the National Portrait Gallery, the portrait of President Trump, the Trump administration ordered that the references to the 2 impeachments in his first term be taken off the placard next to his portrait in the National Portrait Gallery. So you know what somebody did? Printed up a bunch of cards that said Trump's been impeached twice and stood by his portrait in the National Portrait Gallery and handed them out to people who came by, right? Whatever the policy is that you don't like, there's civil action that we can take that are outside ordinary government channels, not voting, not speech, but doing things, right, in our communities. And then finally, I firmly believe that having conversations like this in rooms like this, and then take this conversation back to your family, to your friends, and continue this outside of this room, I firmly believe that that's how we make constitutional change. And so, you know, kudos to you all for coming tonight and engaging in this conversation, but this is just the starting point. You got to go back and talk to your community. Yeah.
Back to your DI, what if you were giving some illustrations earlier about the unitary theory and these spheres? Can you just verbalize how they're using their philosophy with DI to extend into things like moving backwards about climate change or historical markers about slavery and, you know, and modifying and rewriting history
Yeah, so it's a really good question. The question is, what is all this stuff about removing references to global warming? references to slavery from national monuments, that kind of thing. How does that fit within all of this? It's not clear to me exactly what their theory is, but I think that I think you're right. I think that they see that as part of their anti-DEI effort. But it also fits squarely within the unitary executive theory. If the president has plenary control over the Article 2 branch, they also have plenary control over the national parks. And they can take down references to slavery, you know, at the slave house in Philadelphia, for example. That's part of the national park system. Or they can take down references to global warming in national parks, and basically put up whatever they want. And so that really is just this kind of robust unitary executive theory. Yeah.
Okay, shifting a little bit, and you mentioned agencies make rules. I'm familiar with agencies that make rules, prosecute violations of those rules,
Yes.
and then decide those cases that they've prosecuted. How does that fall into the checks and balances?
Yeah, this goes back a long way. So we have long accepted the idea that federal agencies can engage not only in rulemaking, but also adjudication to enforce their rules. The hitch is that any final agency decision has to be appealable to a federal court. And so if it's appealable to a federal court, then we have kind of come to understand that that satisfies our checks and balances system, and that it's not an encroachment on the judiciary, which you might otherwise think that it was. Yeah.
Okay, but isn't the appeal limited? I mean, like, and I'm more familiar
We
with the
can't
state.
hear you.
I'll repeat it. I'll repeat it. I'm sorry. I'll repeat. Yeah.
Okay, but the appeal tends to be limited, and I'm more familiar with the state court proceeding.
Mhm.
So if an agency finds a fact, court is not likely to overturn that fact finding.
In some cases, that's true. So the question was, agencies can engage not only in rulemaking, which we talked about in the notice and comment stuff, but also adjudication, which means that agencies have what we call administrative law judges. They're not regular judges in a federal court. They're actually judges in the administration, in the Article 2 branch, that hear these cases as a kind of enforcement of an agency's rules and regulation. And the question was, how does that satisfy the separation of powers, especially when some of those decisions then become locked when they're appealed? And my reply was, we've kind of long accepted the idea under something called the Administrative Procedure Act that agencies can engage in both rulemaking and adjudication. On the adjudication side, the idea is that their decisions have to be appealable to the federal courts, that the federal courts have to have the final say-so in those cases in order to kind of make that all square with our separation of powers system. And then there are some kind of nits along the way. Do they really get to do that? Because if an agency decides the facts, they become locked, or if an agency can or cannot decide a constitutional question and what that means in terms of agency enforcement. So there are a lot of kind of wrinkles in that, but the fundamental answer is that we have kind of accepted that as a part of our separation of powers, with the significant caveat that the federal courts get some level of review. Yeah. Yes.
There's a number of decisions that are coming this year, I think, right? With the Supreme Court.
Yeah.
Immigration, birthright, and so forth. Based on what you've been saying, and you don't have a crystal ball, I know that, but how do you see some of these decisions coming out, for example, immigration?
Are you thinking birthright citizenship in particular? Yeah.
You can listen tomorrow.
Yeah, you can listen tomorrow. They're going to hear the case tomorrow. Yeah, oral argument is tomorrow. You can hear live, by the way, to go to supremecourt.gov, and you can log into their live telecast. It probably will go several hours, would be my guess. So, buckle up, make sure you go to the bathroom before you sit down for it. I think in the birthright citizenship case, my guess is that the court is going to reject the Trump administration's theory and do it pretty decisively. It's always a little hard to say. I don't know. And the court has done some really surprising things this past year, including some of the shadow docket things that we've talked about. But I don't think it's going to overturn what we've come to understand as birthright citizenship under the 14th Amendment. That would be a really dramatic thing. Yeah.
So basically Hitler revoked birthright citizenship. If the court decided that, birthright citizenship wasn't a thing anymore, could Trump do what Hitler did to the Jews?
Well,
What's the question?
the question was, if the court were to revoke birthright citizenship, could Trump take a further action kind of in the spirit of Hitler and Nazis? I mean, the technical answer is no, right? I'm hesitating because we've seen the Trump administration take some pretty aggressive immigration enforcement action. And so I want to be clear about the implications of the decision on birthright citizenship. If birthright citizenship goes away, first off, the Trump administration has said that that only applies prospectively. So they won't enforce it according to their commitments to the court. I get that they're not always the most trustworthy source, but they've committed to the court that they'll only enforce it prospectively. What that would mean then is that children born in the United States would not have birthright citizenship and would be subject to the kind of treatment that we've seen ICE and DHS agents use in, places like Chicago and Minneapolis and LA and everywhere. In order to remove them from the country. So to that extent, it could mean that. Again, I really don't think the court's going to do this. They might surprise me, but I don't think so. And let me tell you partly why. Just a couple of weeks ago, the Supreme Court struck down President Trump's tariffs, right? And what they said was that President Trump didn't have authority under a statute called the International Economic Emergency Powers Act. The acronym is IEPA. That act allowed the president to regulate some aspects of the international economy, but it didn't specifically authorize the president to impose tariffs. Other statutes did allow the president to impose tariffs, but in a much more circumscribed kind of way. The president was trying to sidestep those statutes by using IEPA to impose these outsized tariffs across the board, right? And the court said you can't do that. Now, what does that have to do with birthright citizenship? This is a court, despite what all appearances, this is a court that will occasionally push back and tell the Trump administration they've gone too far. Not often, right? But they do occasionally. Now, some people who study authoritarian regimes make the argument that that's strategic, that constitutional courts or government high courts will sometimes check an authoritarian just to kind of keep us all under the impression that democracy is still working. Right. That's the theory. I'm not sure you can use your own judgment. I'm not sure I agree with that or disagree with it. But some who study, authoritarian regimes around the world have made that argument. I don't know if that's what's going on. I just don't really have any idea. But what I do know is the court's willing to push back sometimes. And I think it's going to push back in birthright citizenship.
Is there an example where the court has pushed back on the Trump administration where it did not involve money or investment?
Yeah. So, yes. In the first Trump administration, you might remember that the administration used this kind of wild and wacky hackneyed theory to try to put a citizenship question on the census, if you remember this, right? And they kind of jerry-rigged the whole thing so that they actually got administration officials, high-level administration officials, to write to each other to say that we need to do this, we need to collect this information in order to enforce the Voting Rights Act, which everybody understood was just crazy. And the Supreme Court said that. Yeah,
So, Professor, can I force you to pivot
of course. Yeah, please.
to war powers, which was, I think, one of the things we hoped, and we got a great question from somebody in the audience. Since Congress hasn't declared war on Iran, and we know that historically presidents have taken action without congressional authorization, going all the way back to Truman in Korea. But Trump has now lifted sanctions on Iran and Russia, or at least Russia doing business with Iran. So so effectively Russia funding Iran to fight us. I mean, how does this fit into the scheme as developed by our founding fathers?
So,
Like, what would they make of that?
yeah, and this is a story of constitutional evolution as well. Going back even before the Nixon administration, but to the War Powers Resolution in the early 1970s. Three things have happened in recent months that involve war powers. One, obviously, is the Iran war. Another is the Trump administration's attacks on fishing boats out of Venezuela. And a third is the capture of Maduro in Venezuela. All three involve the use of armed forces in different ways. None of them involved a declaration of war. Congress has the power to declare war. As you correctly said, that has lightened up over time. Most recently, Congress enacted authorizations for use of military force in Iraq and against Al-Qaeda, two separate AUMFs in the so-called War on Terror in the early 2000s. The one against Al-Qaeda is still on the books and still used by the military. And an authorization for use of military force is the functional equivalent of a declaration of war for separation of powers purposes. But what happens when the president is doing these significant actions without a declaration? Well, the justification is somewhat different in the three cases, as best we can guess, because the Trump administration hasn't really laid out a clear legal justification for these actions. We'll start with Venezuela. In Venezuela, the administration went in with the assistance of the military to capture Maduro, which they couched as a criminal enforcement action. So the idea is FBI agents are moving extraterritorially outside of the United States to capture somebody that they say has violated US law, bring them back to the United States. But we're not going to send in FBI agents to do that themselves because it's very dangerous. So they get support from the military, right? And the theory is that that's not war because the military is supporting a law enforcement operation. Okay, so that's that. With regard to targeting fishing boats off Venezuela and in other areas, this is typically a civil enforcement action that the Coast Guard would spearhead. The Coast Guard, in its capacity as a civil enforcement, a civil, not military enforcement agency. And what they typically would do is intercept these boats, capture the people on them, bring them back to the United States for trial in a regularly constituted Article III court. But what we know instead is that the military has been striking them with drone strikes and summarily killing them. We have a name for this in US law. It's called murder, right? And so the question is, how in the world do they justify doing this? Well, the Trump administration, and this is all very foggy, they really haven't set out a clear legal justification for this. But what they've said basically is that these folks are terrorists. We have good reason to believe that they're terrorists, believe us. And so therefore we can strike them. Now, that sounds like a crazy claim, but I'll maybe remind you or let you know that in the Obama administration, President Obama took exactly the same stance and drone killed Anwar al-Awlaki and some of his relatives who had nothing to do with terrorism, conceitedly. They were collateral damage in the drone strike, under the theory that the administration had validly determined that he was a terrorist operating under the AUMF that I'd mentioned before, and therefore was drone strikeable, and that the administration had provided him due process. The third one in Iran. So if you listen to what President Trump is saying carefully, you know that he very carefully has not put troops on the ground. There's a constitutional reason for this. An office in the Department of Justice long ago kind of planted a seed that there's this idea of hostilities that don't rise to the level of war in the constitutional sense. In other words, there are some uses of troops that aren't war, right? And that's going to depend on a lot of things. It's going to depend on the projected length of the deployment. It's going to depend on whether there are troops on the ground, how many, what are the likely casualties. A whole host of questions kind of go into answering, does this rise to the level of war in the constitutional sense? And if you look at the way that President Trump has intentionally prosecuted this war, his argument is it doesn't rise to war in the constitutional sense, and therefore I don't need a declaration. Is that something?
Like Vietnam.
Similar to Vietnam, although in Vietnam, you did have, at the beginning, you did have later some congressional resolutions.
Providing support to the enemy is considered to be treason and sedition if it's not a war. So since we are funding our enemies, isn't that legally problematic to fund our enemies?
You're saying by lifting the sanctions?
So when we look at sanctions and we also have increased the price of oil, we are giving them a huge profit margin, which they are then using to fund spying agencies telling Iran exactly where they should send their drones so they can kill Americans. And so we are funding killing Americans. We Americans are funding killing Americans.
Yeah. The courts, they're obviously not the only way that you enforce this kind of thing, but the courts basically don't check the president on issues of national security like that. And so we just don't expect any judicial pushback. That doesn't mean that there aren't other things. We talked about impeachment earlier, voting the person out of office, obviously, right? There are other remedies. Call your members of Congress and tell them to wake up and do their job. Or call, for goodness sake, call other members of Congress. Ours are doing a great job. Call others and tell them to do their job.
I have an unrelated question.
Yeah.
Is there a way to impeach Supreme Court justices? How would
Mhm.
it occur?
Yeah, absolutely. Congress can do that. I would not hold my breath, but yeah, they can do that.
And is there any, is there any cause?
The question is, can you impeach Supreme Court justices?
Yeah. So the standard is going to be the ordinary standard for impeachment that applies to anybody. And the way that we interpret that today is basically if Congress deems it an impeachable offense, Congress can impeach. It really is in that sense, there's a technical phrase that we use in the law. It's called political question. And what that means is not that it's a question of Democrats or Republicans or Green Party or whatever, but that it's a question that's committed to the political branch without a judicial oversight or check. And functionally, what that means is Congress can do what it wants in the area of impeachment.
In the interest of, yeah,
Well, I'm sorry.
Way to impeach the Supreme Court?
Yeah, there have been moves to impeach Supreme Court justices. Absolutely. Again, I would not count on it in today's politics. And so the thing is here, and this might be you're prompting us to stop, I know.
no, I'm segueing to voting. We are the
Oh,
League of
okay,
Women
awesome.
Voters.
Well, okay, so let me just say this. I think both parties in Congress are smart enough to realize that if they do this one way, it could come back and bite them a different way in the future, right? And so they're going to be a little cautious for doing that kind of thing. So imagine Democrats take control of both chambers in the midterm elections and move to impeach Justice Thomas or Justice Alito, right, which are commonly the sort of on the far right side of the court. I think they're going to be pretty reluctant to do that because they know if Republicans retake both houses, which they inevitably will at some point, they're going to move to impeach Democrat Supreme Court justices.
Okay, two questions related to voting. As I said, we are the League of Women Voters here at the library. One relates to the SAVE Act, and currently it's already illegal for non-citizens to register to vote. So what is the message that that particularly the Republicans are trying to send with the SAVE Act? That's sort of one piece. And then secondly, there's a new executive order on mail-in ballots. And do you think that's going to stand up?
So on the SAVE Act, this looks like it's probably not going to pass unless something different happens in the Senate, that it probably will not get past a filibuster. It would require proof of citizenship for registration and then voter identification at the polls. The way this currently works is that and maybe you know this because if you've registered, you would know, you've got to certify that you're a citizen of the United States and qualified to vote. That's not nothing. Lying on a federal form is a big deal. You can be prosecuted for that. You can be prosecuted for registering and for voting as a non-citizen. This almost never happens, but when it does, it's prosecuted and people go to jail for it. It's a really big deal. So there's a strong deterrent and not a huge upside, right? I mean, we all know that voting is really important, but we also know that our vote is just one vote. And so are you really going to risk going to jail for 7 years to vote as one person, right? Is kind of the theory behind Congress's approach to this. Republicans that are pushing the SAVE Act say, well, we need to do this to clamp down on voter fraud, which really isn't there. And so it looks like
It's a solution in search of a problem.
Jinx. Yeah. Yeah. And, what are they doing? I don't know, virtue signaling, maybe trying to scare, I don't know what they're doing, but it doesn't look like it's going to pass. With the mail-in ballots, this is actually before the Supreme Court right now, which is maybe what caused President Trump to issue the executive order. So, and one of these cases actually came from a downstate congressman right here in Illinois. The challenge is that mail-in ballots are illegal if they're counted after Election Day. And the reason is that because federal law sets a particular day, the Tuesday after the Monday in November, sets a particular day as Election Day. That day is the day in which ballots need to be counted. So for states that authorize mail-in voting, so long as it's postmarked by Election Day, but will inevitably be counted after Election Day, they can't do that under this theory. Now that's at the Supreme Court right now. And the Supreme Court, I think, very well might say that Election Day is Election Day and mail-in ballots have to arrive before Election Day in order to be valid. I think that's a real possibility in this case. And Trump seems to be riffing on that and saying, okay, I'll issue an executive order and just categorically say mail-in ballots are illegal. Now, he can't do that under federal law. He doesn't have authority. He needs legislation to do that. But it might not be nothing if the Supreme Court rules in the way that many of us expect.
Okay, can I go ahead? Couple other questions here.
Aren't the military always coming in late for votes?
Yeah.
I mean, and that's been allowed for years.
Yes.
Okay.
And some states do 100% mail-in voting. Yeah. What this is going to mean functionally is that mail-in, it's not going to mean mail-in voting goes away, but will mean that mail-in voters need to time it so that their ballots arrive by Election Day, which, let's go back to unitary executive theory. If you pay attention to what's going on in the Postal Service, not hopeful signs here, right? And again, President Trump has asserted a kind of muscular unitary executive theory over the Postal Service, which of every agency, the Postal Service, I've looked at this in detail, the way that this is insulated from political control is just jaw-dropping in the Postal Service. And President Trump has just steamrolled all that law and said, I'm going to take it over. Yeah.
Question, so let's say that I vote and I give it a week to get there, and at the end of the week, I vote as a crowd because the postal service sucks. Can I sue the postal service for preventing me from voting?
You can sue anybody. I'm thinking that's probably not going to work though. Yeah. Yeah. That's a good try though.
Purposely to prevent you from voting. Sorry.
I think I think the library closes at 9 o'clock, right, Ryan? So if your car is in the garage, you need to get it out by 9. I first want to just thank the professor for coming up from Naperville, educating all of us.
Thank you.
Thank you so much.
Thank you.
The library has a lot of books and other information on all of the issues we talked about today and a whole lot more. Ryan and Lindsay are always here to help you, and this is really a fabulous library. So make full use of it. Okay, so now I'm going to promote Steve's monthly online discussion of similar constitutional law topics, the League of Women Voters of Wheaton. You can go online, sign up, they'll send you a notice, you just log on from wherever it is you're comfortable logging on from. And it's the third Thursday
Third Thursday
of every month. For how long now? The whole year?
We're going the whole year.
Yep, the whole year. So if you like tonight, you can come back every month online, and it's really good. The other thing is the league and the library are again collaborating. August 17th, Professor Schmidt from Chicago Kent will be here, and he's going to be focused solely on the Supreme Court. So make notes of all of your Supreme Court questions between now and August 17th. And thank you to everybody for coming. Don't forget to vote. Vote. I won't say multiple times, just once.
Vote with your voice.
Yes, you can vote with your voice. So thank you so much.
Thank you.